Perfect. Morning, Bruno.
Awesome. Hey Nick, how you doing?
I'm fine, thanks, and you.
Good. Yeah, short week. Hope it's productive. Hope we get through a lot of stuff.
Hmm,
We've got three questions today. So let me throw the first two at you.
perfect.
Um, I'm going to have a quick look at them. So the first one I think is going to be quite a short answer. Due to bad weather, a kitchen window broke, but unfortunately damaged the tenant's car. Now the tenant wants to claim damages. Can he claim damages?
Okay, so we'll give the short answer on this.
Okay.
Okay, just with regards to damages. The way damages works in South Africa is you've got to be able to impute those damages onto a particular person. So you've got to show that their conduct caused the damage at the end of the day. And then importantly, you've got to be able to quantify the damages. Quantification doesn't seem like a problem in this case because you can say, well, whatever the damage is, this is what it takes to fix. But there is a real difficulty in this sort of question with regards to why the landlord is liable for the damage in the circumstances. If it's caused by the weather and it just happens to be a window that broke and it damaged the car, it's not the landlord that brought along the weather, unless the landlord has done some sort of
Mm.
warranty that your vehicle will never be damaged in their property whatsoever. Unless there's that, it's very unlikely that you're going to be able to put this conduct onto the landlord. And the reasons are simple. I mean, uh, you could also argue that you decided to park your car in the way of the window
Mm.
in the circumstances. The landlord didn't tell you to park your car there. There are too many
Yeah,
variables. So unfortunately, you're not going to be able to say that the landlord is responsible for the weather. It's an unfortunate event. That's why you have vehicle insurance.
absolutely. So just to add on to that, if for example there was like whatever a a repair of the window that the tenant knew was a really bad repair and he had notified the landlord, but that goes back to Nick's point, is there's an act of negligence. That's identifiable, foreseeable damage could have been caused, but the landlord did nothing to stop it. Like the window was falling, it was like on a 45-degree angle out of the putty. The tenant had reported it, for some reason didn't remove the pane, and the landlord had left it for 3 months and now it fell.
Yeah.
Slightly different story, although to be honest, even in those circumstances, going to what Nick said, as a tenant, you don't park your car if you know that something's going to break and there's a risk, because you actually carry a duty to mitigate your damages. So in that instance, there would be also a contributory negligence on the tenant's part. But yeah, it's not going to be an easy one. No. There
Yeah.
might be an insurance claim though, to be honest, which possibly, but that's a different story altogether.
Yeah.
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 And then the second one, I rent out a property which the owner passed away. It's similar to a question we got before. So everyone lived in the UK. The son is the only heir. The letter of authority has not been issued yet. So that just basically means that the master's office hasn't officially appointed anyone to be the executor. In essay, I let him sign as de facto for the meantime. So this is the son. Now, the question, he wants the rent to be paid into his account because his mother's accounts will be frozen and he is the sole heir. Does this not sound logical? He doesn't specify who's supposed to be appointed as the executor, though. He just mentions that this is the sole heir, and he mentioned something about the mother's accounts being frozen, which makes me assume that she might be the executor, but not sure. Yeah, so he just basically wants to know, where does he pay the rent?
Mm. Perfect. So the starting principle of this is to deal with what happens to your lease agreement in the event that someone dies. Okay. And um, what you need to be careful about is that we get a lot of questions about, well, someone died, the lease disappears, and that's not how it
Hmm.
works. Okay. Your lease agreement will survive the death of either of the parties contracting. The lease is just falls into the estate of the person who has died. Okay, so the estate is technically the contracting party in the circumstances. That estate is controlled by the executor. Okay, the executor is the person who is appointed in your will, or if you don't have one, then appointed by the states in the circumstances. And that executor is then in control of what do we do with this particular contract. They need to wrap this up and figure out what happens with these particular contracts. All right. So the lease agreement is still in place. As you said, Bruno, what we don't hear is who exactly the executor is in the circumstances. So what I want to caution in a case like this is you need to be very careful about what agreements you enter into before an executor is appointed. Technically, the only person that can deal with the estate and indicate where or what to pay or what account it is the executor. Now, we have to, deal with reality in South Africa, and unfortunately, our master's office is not the most open institution that we have. Okay, and sometimes these things takes time. Okay, so we do have to make sort of plans in between while we wait for the master to get their functions done, and so it's not. This is something that's quite often done, okay, because these circumstances do particularly happen, but you need to be very careful if, as the tenant, paying your rental into an account. The first thing you want to do, find out who is going to be the executor ultimately. Okay, still within the discretion of the master ultimately, but at least if you know that this person will ultimately be appointed as the executor, you know you're dealing with someone that won't come, that isn't completely foreign to you at the end of the day. So if there's a will saying this person is going to be the executor, deal with that person. Okay, they're basically just in waiting um, before the master goes through all of their red tape and appoints them. Okay. In terms of this question, you've said that the son is the heir of the estate. Be very careful. The heir of the estate is not the person that is in control of the estate. Not necessarily. They can be executor and heir. That's absolutely fine. But the fact that they are heir does not mean that they will control that estate. And in particular, this question, you said the mother is still alive. Now, it's very possible that someone appoints their child instead of their partner as the executor of the estate, but it's not necessarily so. So my advice in the circumstances is go and check, find out who is going to be appointed as executor. If it happens to be the son, and you're now waiting for the master to go through their processes, and the son sort of says, well, we're going to pay into this particular account, you also need to be careful because those payments, while they are being wrapped up in the estate, are technically estate payments. So they still have to be dealt with in terms of the final liquidation and distribution account, which is submitted to the master in any event. Okay, they do have to be accounted for, but perhaps there can be ways that you guys can deal with what account those get paid into in the interim. But please don't think that those payments can just go to the son now and they become the son's payments. The liquidation distribution account needs to be lodged with the master. It needs to be approved by the master before any distribution occurs in terms of a deceased estate. And so it's not as simple as I'm just going to pay the son and not let the master know about these particular payments. There can be serious problems if that happens. All right. But really find out who the executor is the primary thing here. Because they're also going to be the one that's responsible for making sure that a proper account is given to the master in the circumstances. So just make sure you're dealing with that person and you can go from there. All right, perfect. And Bruno, I've got one question for you for today. So it's a question from a property investor. Basically, the circumstances are that this property investor purchased a property, okay, but the seller in the circumstances was under foreclosure by the bank, okay. And the seller had entered into they accepted the offer, but they had also entered into an easy sell agreement with the bank in the circumstances. So now there are basically two different agreements, and now the purchaser is asking, what exactly is the recourse in the circumstances with regards to the seller?
So buying property from a distressed estate. All this basically means is that the seller in this estate, for some reason or another, has failed to maintain the property or at least to pay the bank any loan repayments that are due. So buying property as an investor from a distressed estate is obviously has an upside to the investor in that they're able to better negotiate prices, as an example, and works for the actual seller or the owner, because in those circumstances, they may need some sort of financial injection in order to get them out of this financial debt. So for property investors, it's something that happens very often. Unfortunately, not a lot of people do their due diligence before making the offer, or at least provide a period of due diligence whilst like a suspensive condition for the purposes of this due diligence. Now, when I refer to due diligence in these circumstances, what do I mean? Is it the condition of the house? Yeah, no, naturally, because the condition of the house is also something that should be borne in mind with every sale, but particularly with houses that are distressed, because there's almost a guarantee that the property hasn't been maintained in a particularly good condition. But part of the due diligence also where the bank is, because the bank has the mortgage secured in its favor in order to collect any outstanding debt. So one needs to always double check, where is the bank in this process? Because if the bank is very close to an auction, as an example, the bank is very unlikely to pull the auction and agree to a sale taking place without receiving some form of payment, almost as security or as a guarantee that this sale is going to go ahead. Because in the past, what used to happen with investors, especially the cheeky investors and the cheeky owners, in fact, is they used to receive offers, but they weren't real offers. And these offers were for a great price, but there was no deposit payable. And they used to run to the bank and say, look, somebody's willing to buy my property. You're going to get all your money back at once. But the reality is this was the brother-in-law, as an example, right? And it used to happen very often. It was a shelf company that was like removed three times from this person. And then we used to get the other scenarios, for example, where a property investor, not 100% serious, but he liked the idea, kind of got a good price from it, but maybe he had something better, or was going to look for someone else in order to sell the property onto them. He used to go out, make an offer, which was acceptable, but there was no intention of actually binding himself to this offer. So at some point or another, it was almost guaranteed that he was going to pull out of this deal. So the banks obviously got wind of this and realized we can't. We need proper commitment. We need skin in the game. So the banks require payment to be made. And normally this is the arrear amount that is outstanding. So this is the accumulation of all the repayments that have been missed. That's the arrear amount, not the outstanding bond. Outstanding bond is the full amount due to the bank. The arrear amount is just the payments that have been missed. So first of all, you need to find out where you are in this process, because if you're going in with an offer at 100% loan, you're not going to be able to stop the auction from taking place unless you put that cash down and give it to the bank. So all of this should be taken into account in the calculation. Another thing, for example, in this instance, there was a mandate signed for an easy sell or quick sell. Every bank has it. And all this basically means is the banks afford this opportunity to owners to dispose of the properties in circumstances that might be better than a sale and execution, certainly avoid the additional cost of a sale and execution. So it's still almost a forced sale to a certain degree, except it's voluntary, where the seller actually agrees that somebody market the property, market it for a specific price, and that it be sold. And he accepts this as an outcome. And when the money comes in, it goes straight to the bank. And there's definitely upsides to this, because you find that some of the banks incentivize the sale of these easy sales or quick sales by offering a discount on any arrears or any shortfalls. So if the property sells for $1 million, but the bank was due 1.2 million, there's a difference of 200,000. Some banks would even discount this or offer a payment plan towards it. So there's definitely a lot of incentive for a seller to sign it, making your life as a purchaser difficult, because if the seller signs it and he knows he's going to get that upside and there's a competing offer, now it's your offer and their offer. And that's all good and well, provided that these offers haven't been accepted. Unfortunately, in real life, you start having the conversations over, but which offer is actually enforceable? Was it the one that was signed first? What about the mandate? Because if they signed a mandate where the seller wasn't permitted to sell the property and sold it nonetheless, there's the question over that and the seller's authority to be able to sell the property, and whether you can still enforce that sale, which I am of the opinion that you can, and you can enforce the sale, provided that any offer subsequently made provided that there isn't a competing offer that was accepted before yours. And that's sometimes the risk, is they accept your offer, but it turns out that somebody made an offer beforehand, it was accepted beforehand, and something just delayed there, and no one ever bothered to cancel that. So there is an element of due diligence that's very, very important. I'd always find out this information. I'd always have clear warranties in the contract to say that there are no other pending offers, that no agent is under mandate to sell this property other than the agent that brokered this deal, just to clarify certain things, and definitely giving you authority to be able to communicate with the bank, or at least being involved in the communication with the bank in order to ascertain where everyone is in the foreclosure process.
Perfect. Thanks very much, Bruno.
Cool.
And that brings us to the end of PLA for the day. Thank you so much, and we'll see you next week.
Well, thanks.